Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the NYSE MKT listing requirements. In particular, today I'm going to talk about the seasoning rules. The seasoning rules were adopted in late 2011 by multiple national exchanges, including NASDAQ and the NYSE MKT, in response to a request from the SEC for the exchanges to limit the ability of companies to uplist following the completion of a reverse merger transaction with a U.S. public shell company. The SEC request came as a result of a slew of reverse mergers from China, where the representations related to the financial condition of the foreign companies turned out to be fraudulent. The seasoning rules prohibit a company that has completed a reverse merger with a public shell from applying to list until the combined entity has traded in the U.S. over-the-counter market, the OTC markets, or another national exchange, or on a regulated foreign exchange for at least 1 year following the filing of all required information about the reverse merger transaction, including audited financial statements. The rules require that the new reverse merger company has filed all of its required reports for the 1 year period, including at least one annual report on Form 10-K. The seasoning rule requires that the reverse merger company maintain a closing stock price equal to the stock price requirement applicable to the initial listing standard for a sustained period of time, but in no event for less than 30 of the most recent 60 trading days prior to the filing of the initial listing application. The rule includes an exception for companies that complete a firm commitment underwritten offering resulting in net proceeds to the company of at least $40 million. In addition to the specified additional listing requirements contained in the seasoning rules, the exchange may, in its discretion, impose more stringent requirements for companies applying after a reverse merger if it believes it is warranted based on, among other things, an inactive trading market in the reverse merger company securities, the existence of a low number of publicly held freely tradable shares, if the reverse merger company has not had a Securities Act registration statement or other filings subjected to a comprehensive review by the SEC, or if the reverse merger company has disclosed that it has a material weakness in its internal controls and has not yet implemented an appropriate corrective action plan. Although the rule only refers to a reverse merger with a shell company and not an existing operating business, in my experience, both NASDAQ and the NYSE MKT will take the position that almost all reverse mergers are completed with a shell company. Even if a company has taken the position that it was not a shell company and has not been challenged by the SEC, the NASDAQ and NYSE MKT will make its own determination and will review on this point. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.